Good morning and welcome to our CEO Training Division series. Or good morning, it's actually good day now. But welcome everyone to those tuning in on Facebook, LinkedIn and YouTube. You're very welcome here. Just 1 or 2 points before I introduce our speakers today. I'm very excited to be presenting this bit of a different training session today. Today's topic will be advocacy alchemy, and we'll be touching on a bit of courtcraft for our members and legal representatives or anyone who's interested in the CCMA, the Bargaining Council, and how we conduct our arguments there. So quite a different take on today's discussion. Today I'm joined by 3 guest speakers. First of all, Jean-Ray Kruger, our National Operations Manager, then Edrich Fourie, a dispute resolution official here in the Free State Northern Cape region, as well as Kenneth Knox, also a dispute resolution official here in the Free State and Northern Cape region. Welcome, everyone. How are you guys doing?
Morning, Carl. Thanks. Thanks for the opportunity. Coming from a very cold Bloemfontein this morning.
It is rather chilly here as well. Kenny, how are you doing?
No, I'm good. It was a eventful weekend. Back at it today.
Okay. And Ed, welcome.
Thanks, Carl. Yes, I am doing very good after the weekend. So yeah, I'm excited to be here today.
What a proud day for South Africa, given the 4 times World Cup champions. Jeez, it's a wonderful day to be doing this, and coming from a action-packed weekend, I think it's quite exciting. Good way to end off 2023. And yeah, go Bokke. I was going to wear my South African rugby jersey, but after the weekend, I don't think it was such a good idea after the game. Got a bit interesting.
Mine also paid its dues. That jersey worked hard over the weekend.
100%. But anyway, without further ado, just some housekeeping quickly. We are streaming on multiple platforms. You can tune in on your computer or on your smartphone. We are live on LinkedIn, Facebook, and YouTube. For those people just joining in now, welcome. The video recording slides, as per our previous training sessions, the video recording and the slides will be made available on all our social media platforms. Please have a look there after the training, or if you can't finish watching this whole session, it will be made available there afterwards for you guys to tune in and watch. Regarding our previous training sessions, I just want to say thank you to all our supporters, to all our viewers. We've reached a couple thousand views on all of our videos. So thank you so much for tuning in, for listening. We really do appreciate the support. As with our previous training as well, this is an interactive session. For the people tuning in, there is a comment section there on LinkedIn, YouTube, and on Facebook. Please feel free to pop your questions as we go. We are taking the questions and dealing with them live on air. So if you have a question or you're interested in a specific topic that we're talking about, please feel free to pop your question in there and we can address it to our guest speakers. Please don't feel shy to participate. We are all here to learn and grow as individuals as well as professionals, and hopefully you guys can enjoy this interactive session. All right, the discussion today, we're taking a bit of a different approach to our online series. This is still part of our piecing together the processes, which we started early on in the year. We've been doing 1 training session per month for our viewership. And today we've got a few different topics specifically under trial advocacy or advocacy alchemy. The first one we'll be discussing is trial advocacy itself, followed by narrowing of issues, opening of statements, hearing of evidence, and then closing arguments. I've got my expert panel of my legal expert panel here to discuss each topic. And without wasting any further time, let's jump right in. So trial advocacy, obviously you guys coming from all a legal background, Jean-Ray, I think I'm going to pose this one to you first. Maybe if you can give us a brief overview of what trial advocacy is for our viewers.
Yeah, look, thanks, Carl. And again, thank you very much for the opportunity. It's always great to be able to speak to our broader member base and, just general followers of our social media platforms. We were lucky enough to give class to some of the university students on Friday. So I hope some of them are here as well. Welcome if you are. If you're watching later, welcome as well. Look, trial advocacy, what is that? It's basically, how will we eloquently put it? It's the dance that lawyers do, the dance that attorneys do, to try and obviously convince whoever is the presiding officer in your matter. If it is obviously we, work a lot within the CCMA and arbitration sphere. But I mean, anywhere, South Africa is built on a law system where you usually have a presiding officer, be it a magistrate, be it a judge, be it multiple judges. So firstly, trial advocacy is how do I convince and how do I prove my case so that individual finds in my favor, and then how, obviously, the legal sphere is always a little bit of jousting between two parties, and how do I best curtail my craft to the best of my ability to make sure that the facts that I present and I put over, and that those facts that I put over are convincing enough to sway a presiding commissioner. So it's something that's also quite remarkable, myself coming, I studied as well, and you did articles, and you becoming an admitted attorney. It's not really something that obtains a lot of focus, from the universities. It's very difficult to just teach someone trial advocacy. And we're going to move through the stages here today of, what should you do, and, build guidelines. But inevitably, the only thing that's going to advance your trial advocacy is actually going and putting it into practice, making sure that you build your knowledge and you become comfortable within the knowledge that you possess, and then obviously how to carry that over to not just your opposing party, but also, as I said, the presiding commissioner as well. So I'm very excited. It's something that it's not always tangible. It's something you need to learn and something that you need to work on a daily basis. And I hope through this guide we can at least assist the viewers here today in just peeking behind the curtain a little bit of guys that might have been doing it a little bit longer, and that people that might still be entering the labor sphere. So thanks, Carl. I'm looking forward to today.
100%. Thank you, Jean-Ray. Very experienced kind of answer for our viewership as well. A bit of trial advocacy background there. So for people who are maybe a bit newer to trial advocacy, is that something that specifically within the context of the CCMA and the Bargaining Council, and I'm going to say our realm of expertise, how and where does it actually fit in? So we've dealt with the processes, where does it fit into what we do at CEO?
Yeah, look, your trial advocacy really comes to play when you're in the arbitrating arena, but it's not just about that. It's obviously the preparation before the time, ensuring that your documentation is correct, and ensuring that you know what path you want to walk, with your matter and with the facts at your disposal. So it's not, obviously, as I said, it comes to the fore, and you can see it in full flight during an arbitration process. But it's a little bit more than that. It encompasses everything, and it almost becomes a type of a personality trait. I always say, we all become lawyers because we're watching Suits and Boston Legal and stuff like that. But that's what those guys do. The Harvey Specters, the Alan Shaws, they have a way of carrying over the information and convincing the presiding commissioner, and, as I said, jousting with the opposing party. So as I said, it comes to light during the arbitration process, but it encompasses my entire preparation and how I look at my matter, before going to present it. I don't know the boys from the ground what their opinions are.
I was actually just about to ask. So you mentioned that it's a personality trait, and I think this one is more aimed at Edrich and Kenneth being on the ground, having to deal with trial advocacy on a daily basis, attending arbitrations for our members. So boys, let me phrase it this way. Do you think that trial advocacy is a skill that can be developed or honed, or is it more of an inherent trait that people are just, good at?
Carl, if I may, I think some people are born with a skill to litigate and to arbitrate in our instance, and to convince someone why their case is the best and why they should win their case. For other people, it's something that you can learn, and I'm of the opinion that it comes with time and with experience. The more you do it, the better you'll get. Some people, your SC council, some of them were born with such a skill. Some people went through the processes, been doing it for some time before you can develop a skill to actually litigate, convince someone, tell someone what they want to hear or need to hear for your case to be successful. Some people are born with it. Unfortunately, some must go through the processes, and time will tell.
Wonderful. Thanks,
Yeah,
Kenny.
Cole, let me jump in there. I actually,
please.
I completely agree with Kenneth. Certain people have the innate knack to do that, and I go back to my previous statement that sometimes something that's a little bit overlooked by universities. Sometimes, some of us were lucky enough to maybe attend certain moot court sittings at our respective universities and stuff like that, but inevitably it's something that you're going to, it's going to be a muscle memory thing as well. You're going to have to put, I won't say your 10,000 hours into it, but I'm pretty sure some of those essays Kenneth has been talking about has put in that amount of time. So because appearing is not always a natural thing, and we'll probably get down to debates and who partook a little bit later, but that is it, exactly it. You'll have to put yourself in situations where you can learn to think on your feet, and obviously develop that type of skill, moving forward.
I think it definitely is a skill that gets better with age, especially if you're trying to hone it and you're exposed to that litigation process or arbitrations on a daily basis. Ed, what is your opinion?
Yes, thanks, Cole. Yeah, like they said, I mean, for me, it's like art. It's a skill that you can develop, and what's interesting about it, it's each person has their own way of going about it, and you need to make sure that at the end of the day, you have your ways that works for you, and it's something that you can develop, and you can work on it. And something that works for me might not work for Kenneth, but you need to know how you want to present your case, and you need to know your case from point A till point Z to be able to prove that in the way you want to persuade the commissioner at the end of the day. So for me, it's definitely something that you can work on, but the most important thing for me is that you need to know yourself and how you want to address your case to the commissioner. Some things might work for me, that's not going to work for Kenneth, for instance. But yeah, you need to know yourself. You need to go and put it there in front of the commissioner the best way you can do it that works for you.
Okay, so I'm actually really glad you said that, because making it so individualistic, what do you think it actually makes, for example, our CEO, dispute resolution officials, good at trial advocacy? What sets you apart from someone else when it comes to trial advocacy?
Well, Cole, yes. I mean, the amount of cases you do at CEO, and the different types of scenarios you work with on a daily basis, definitely, I want to say it just puts you on a bit of a different level. You get so confident in the way you are dealing with the case, and consulting with the members. And also in CEO, we are a lot of dispute resolution officials that all have our LLB degrees, and you can bounce off ideas, but at the end of the day, like I said previously, it's just the way you go and argue that, which make it just put you a bit in a different level from our side.
Great, thank you for that.
So I think sorry, Carl, I'll just jump in. I think what Ed has said there is the amount, the sheer volume of matters that CEO dispute resolution officials would need to deal with, and that's one thing. So obviously doing it more, and making sure that you can hone your skills, and then also we're in a legal fraternity, and myself coming up, as a young litigant, is leaning on other people as well, and learning from their experiences, and putting yourself in situations where you can learn from those type of individuals. So it's a very good statement, and a like an indication of the culture that we try and create at CEO as well.
Yeah. No, and it's a very important aspect of, I think, in any litigant's job description, or on their daily responsibilities and duties, is honing these skills of trial advocacy. So something that I thought wasn't so important when I was at school is I didn't take debating, and I actually wanted to hear from you guys. Did any of you take debating at school? you think it makes you better at arguing, or at least trial advocacy when it comes to it later on in life?
I did a bit of debating. Wouldn't say expertly so, but look, it places you outside of your comfort zone. You know, and Kenneth spoke about it. You know, some people are born with it. So some people are born with this innate skill to speak to the masses. But speaking to the masses versus being able to convince individuals of your case is two different things. But I think debating would really put you, again, it puts you a little bit outside of your comfort zone. And it feels to me that's where you learn. That's where you learn the skills to adapt and stuff like that. So for me, I think debating won't worsen your courtcraft or your trial advocacy. It'll cultivate that type of personality and that type of comfortability in a inherent uncomfortable situation.
Yeah.
Cole, if I can just touch on what Jono just said. With debating, you get a set of facts and you need to present that set of facts. But with a case, you also need to present your set of facts, but you have an opponent that also has the instruction or their set of facts that he also wants to convince, well, the presiding officer or the commissioner in our case. And I think that's a difference between maybe debating, just presenting something to someone, opposed to someone arguing against your case and disputing certain aspects. But I didn't do debating at school. I think I did one moot court at varsity, but there's a huge difference between a moot court and actually walking into court. When I started in practice, the nerves is there, but like Edrich correctly said, you get confident, you get more confidence, you build your confidence, and that helps your court craft.
Yeah, 100%. No, I think it also comes down to the ability of being able to think on your feet. I think that also with experience gets honed, and the quicker you are on your feet to think of, the correct answer or relate to a legal aspect or principle, it also hones your trial advocacy skills. Thank you guys for that. I think that pretty much covers the intro to trial advocacy. Obviously, we are limited with time in these training sessions and we want to get through all the topics. But I really do appreciate that introduction because it sets the tone for the rest of this conversation. So when it comes to narrowing of issues, maybe, Kenneth, I'm going to ask you, you're on the ground, you deal with this. I am personally a big believer in focusing on narrowing of the issues, tremendously going into arbitration. In the context of labor disputes, though, the CCMA Bargaining Council, what does narrowing the issues mean for our viewership? When is it done?
Okay, thanks, Cole. Yeah, the narrowing of issues is usually done before the start of the actual case or before your opening statement. You'll need to tell the presiding officer or the commissioner what is the issues that the parties have in dispute. For example, and I'm just going to use a practical example, if it's not in dispute that an employee, for example, stole a certain object or item at the workplace without the necessary permission, it's not an issue in dispute. You will not go and lead evidence or argue. So with your narrowing of issues, it will be indicated that this is an issue agreed between the parties. And then with the issues that's in dispute, that is what you will actually go and argue and try to convince the commissioner, this is in dispute. Ma'am, this was said by the applicant or this was said by the respondent, and you'll actually go and argue the issues that's placed in dispute when you narrow your issues prior to actually leading your first witness.
Yeah. Okay. So pretty much what I get from that answer is narrowing the issues. It's important because the less that's in dispute, the less you actually have to prove at arbitration.
No, 100% agree. If there's only one aspect in dispute, and I've dealt with a few matters where only one aspect was in dispute, and dismissal is too harsh of a sanction, for example, and you'll just go and lead evidence and argue to that effect. There will be no need to argue about issues that's not in dispute because you're going to place an unnecessary burden on the commissioner to make a decision because the parties don't disagree to that effect. And you need to tell the commissioner, this is the only thing in dispute. You'll argue that case or that certain aspect, and the commissioner will make a decision to that effect.
Ed, I want to say, to put you on the spot here, but any techniques or strategies that you employ when dealing with cases and narrowing issues?
Yes, Cole. I mean, a very important thing for me is to always try and see if you can arrange a pre-arbitration to that effect, especially if unions are involved. The 711 referral form, which normally gets served on the employers, that's not in essence a binding document. So, on the 711 form, the applicant will say what's in dispute, but it can change on the day of the arbitration. Whereas a pre-arbitration minute is a binding document. And if you can have a pre-arbitration or arrange a pre-arbitration and both parties sign that document, it's a binding document. And then you can only argue that on the day what's in dispute on that pre-arbitration minute. So for me, it's very crucial to arrange for a pre-arbitration, especially if a union is involved, so that you can exactly know before the arbitration what is in dispute, and the pre-arbitration can't then change on the day of the arbitration.
I think that also forms a big part of your preparation, because for all the employers out there going into an arbitration, if you haven't had the conciliation process, or maybe it wasn't attended by the parties, and then you go straight to arbitration, you sort of go in blind a bit. I think the pre-arb is an important process where it's possible to arrange it, to hone and to narrow those issues down in preparation of your case, that when you get there, you actually know what's going to be in dispute, what is common cause, what you should focus on with your evidence and witnesses, as opposed to getting there and just sort of, I don't want to say having everything and not knowing really what is going to be in dispute on that day. Any personal experience?
Cole,
Yes,
Cole, I think something I also just want to jump in. I like using the term "time is money." I'll step a little bit into our niche field. Obviously, us as individuals who represent employers, obviously, your employer is always going to have a company to run versus, and versus attending CCMA matters. So it's very important to narrow down those facts. Firstly, so your member or the employer is not overly burdened there. They're not spending too much time there to defend their dispute. And they haven't committed too many resources by way of other witnesses that have to come and testify. And inevitably, we need to understand and acknowledge the fact that we run in the CCMA sphere, and we all know how their caseload looks. So obviously also that courtesy towards the CCMA, your presiding CCMA commissioner, a pre-narrowing of facts will dilute the mud in the water, if I can put it like that. And it'll make it very clear what needs to be decided, what evidence needs to be led, and what are we trying to prove. So I think, if you're sitting in a scenario, and I think Kenneth would have brought that up, in his experience about the just the sanction being too harsh. You've eliminated one element already, which is the procedural fairness. So no need for chairman to come and testify and to lead evidence on how the process went. Now you've broken down the possible disputes, the points in dispute under substantive fairness, and you're resting with one element. So if you use the harshness of sanction argument, is now I basically need to come and prove that, listen, either progressive discipline has been implemented, and secondly, there is a break in that trust relationship. And now we're taking a argument that would take 4 or 5 witnesses down to one witness, and maybe documentary evidence, and being backed up by the necessary precedent, which we'll get to a little bit later in this presentation as well. So I think that's also a very important element of narrowing of the issues, is the time element, not just for you as the representative, but for your member or your client in certain other industries, and then also the very highly impacted caseload of the CCMA as well.
Thank you for that. I think leading on from that, genre, you said, breakdown of the different disputes. So on this slide specifically, I've put a few different disputes, maybe if you guys could differentiate them. So I'll just use the first one as an example, and let me pose this question to you guys. Unfair dismissal disputes. What is the difference that can be placed into dispute there when narrowing the issues compared to maybe an unfair labor practice or Section 73A? If maybe you guys can just elaborate for me a little on that.
Carl, if I may start,
Yeah,
look, with an
please
unfair
shoot.
dismissal dispute, there can be numerous aspects in dispute. From your procedural fairness, substantive fairness can include a number of aspects. So usually in such a case, there's a lot of issues, like John Ray said, that needs to either be eliminated or addressed. And the onus is on the respondent to prove that this dismissal in an unfair dismissal case was fair. If we make a shift to a Section 73A dispute that's quite newly introduced in the CCMA sphere, is that then the onus shifts on the employee or the applicant to prove. Just for clarification, it's if monies are due or allegedly due for unpaid salary, then the onus will shift, and that also changes the narrowing of issues. For an unfair dismissal dispute, an employer or us, we will go and argue that the dismissal was fair because of A, B, and C. Now, if we shift the focus to a Section 73A, we will then argue differently, that these monies were paid. The monies were paid, and during my arguments, Commissioner, when I lead my first witness, they will come and prove that these monies were paid. It reflects in the bank account. So first of all, the onus shifts, and your whole argument to prove your case will also differ.
Yeah. So I think, for unfair dismissal disputes, you can place substantive or procedural fairness in the elements that go under that. I believe there's 17 different elements you can place into dispute. So the less of those that are in dispute, the less evidence and the less witnesses you have to bring to prove your case on the day as an employer. But when it comes to a Section 73A dispute, maybe if you can give us an example for the employers and the members and the viewers out there, what can actually be placed into dispute in a 73A or in an unfair labor practice? Like, there's no procedural substantive fairness there. So what could you place in dispute?
Yes, Carl. Sorry. I think if I can just come in there, like Kenneth said, I mean, the onus and burden of proof to the fact for unfair dismissal dispute and a Section 73 dispute. So, it's important to know, like in a Section 73 dispute, it's for the applicant to come and prove that monies are due and owed to them. So if they can't prove the fact that monies are due and owed to them, then you can place that in dispute, and you can say that from our side there is no monies due and owed to the applicant, and they need to come and prove that the monies are actually due and owed to them. The same in unfair labor practice dispute. But for unfair dismissal dispute, the onus and burden of proof is upon the employer. So it shifts those factors. Yeah.
I think something that's also noteworthy, while we're now looking at disputes and the possible issues that might, in the narrowing of the facts, if you look at, unfair dismissal disputes, unfair labor practice disputes, there usually needs to be a balance of probabilities type of decision versus, if you're narrowing facts on a Section 73A, it's in accordance with an amount that's due in accordance with the Basic Conditions of Employment Act. So during narrowing of the facts, one will be able to identify, listen, is there not possibly a way to resolve this even before we get to the CCMA? And that type of a situation with a Section 73A, or even maybe a compliance order, although we have our own fights about compliance orders as well. But narrowing of the facts there might eliminate even the need to go to the CCMA at the end of the day. And as I said, the gentlemen have now all mentioned, where does the onus lie? I think what's also a very important again here is it's not always a attorney on the other side or a union rep on the other side. Sometimes you do sit with individuals who have no knowledge of the law or even the processes in accordance with the Labor Schedule 8 of the Labor Relations Act. So one would need to use those opportunities, even though you can't have a pre-trial per se, but during the narrowing of the issues, make sure that there's clarity on what elements need to be proven.
100%. Thank you for that, John. I think that pretty much sums up and also reinforces what Kenneth and Edric have also said about the narrowing of issues. It's an important tool to use in your preparation of your matter, and where you can hold a pre-arb, which is like a pre-trial in civil court. it's necessary to do so going into the matter, that there's a clear indication. I think it's also a great way to see whether there is a possible resolution of the matter without having to necessarily waste your time through arbitration. So yeah, thank you for that, guys. I think we can move on to opening statements. So this one, I think, is a bit of an underrated aspect of, or when it comes to the arbitration process and trial advocacy in general. Maybe, let me say, Ed, if you could maybe walk us through, I know you've had a few arbitrations recently. If you can maybe walk us through an opening statement, when are they done? What is it? Why do we do it? Why are they important?
Yeah, Carl, like the saying goes, first impressions are important. And I think opening statement sometimes is very crucial, or all the time actually, to make an opening statement. The opening statement will be when the parties go on record, they will introduce themselves in the arbitration, and then the commissioner will ask if the parties wants to make an opening statement, and then yes, the opening statement will be done then. I think what is important of the opening statement is, you can give it's an opportunity for you to tell the commissioner what your case is going to be, what are you going to prove, what witnesses are you going to lead, what documentations are you going to use, is there video footage you're going to use. And it's important for us to say that on an opening statement, like I said, for the first impressions, it might be good to have the commissioner already see what you're talking about, and she also, it's the first time the commissioner will hear what the case is actually about. So I think an opening statement is very important.
Yeah, I'm glad you say that, because I know of a matter recently where a commissioner had informed an official that it was not necessary to do an opening statement. What is your opinion on that? Do you think it's always necessary to do an opening statement? And you talk about first impressions. Do you get a second bite at the cherry if you forgo your opening statement?
Yeah, I mean, for me as an advisor, I will always do an opening statement. I know the commissioners might sometimes not even ask the parties to do an opening statement and just want to go into the merits of the case. But us as advisors can still ask the commissioner, can we please do our opening statement? I want to do an opening statement. I think it's quite a nice way to get the commissioner to know what this case is going to be about and what is it that we are going to prove in our case. It's just to, for the commissioner mind to see that, okay, this is what the respondents are going to prove. And then you lead your evidence based on that and how you're going to prove it. So I think, it's very important.
Yeah.
Carl, if I can just touch on that, sorry.
Please, yes.
So it happens quite often that we get asked to dispose of opening statements. So I would, and this is a personal trait, I would insist on an opening statement, because you just don't want to lead your witness and testify on certain issues. You want to inform the commissioner before that witness starts talking. Commissioner, this is what witness A is going to be to see or to say. This is how she or he is going to corroborate his evidence. But to dispose of an opening statement, I would advise against it. But it cannot really affect the commissioner's decision at the end of the day, because no evidence was led. But it's like Edric said, it's a correct thing to do, to start off and say, Commissioner, I draw your attention to this aspect. This is going to be important, and my first witness is going to prove that. And it automatically gives a picture to the commissioner on where you're going with your case.
No, 100%. I mean, I'm a firm believer. Sorry, Jean-Andre, I'll give it to you now. So we do have a question that came through. So maybe your I want to say your say can also answer the question there. But I just want to say quickly on opening statement, for me, it captures the sort of an overview and a synopsis of your matter, but also not just that, it's an effective way of just working out those little bit of pre-arbitration nerves. and also sets the tone and builds that bit of rapport with the commissioner leading into your case. You sort of said, this is the tone of what we are doing. Jean, before I hand it over to you, I just want to pose a question to you guys that we received in the comments over here. Good day. What are the do's and don'ts in an opening statement?
Yeah, well, Carl, let me take that because it adds on to a little bit what I wanted to say. And I think you guys now used the correct word, picture. You know, you're painting the picture of how your argument's going to be. I like to phrase it more as a roadmap. You know, I'm taking the commissioner through, and let's get into those do's and don'ts. You know, you got to remember, talking out of a labor perspective, obviously, you know, the onus is usually on a balance of probabilities, and I use the term a lot. You know, don't muddy the water. Make sure that it's clear. So those would be my do's within an opening statement. Make sure that you have sketched the clear argument path that you are going to be presenting to that commissioner. Make sure that the commissioner then knows why am I presenting this evidence? What am I trying to prove? Why am I bringing this witness? What am I trying to prove with that witness? And inevitably, what am I going to be asking for? What you don't want to do in an opening statement is start giving evidence and start laying out the inner workings of your case. Obviously, you know, and we've spoken about courtcraft, trial advocacy. You want to paint the clear picture of where we're going. So this is the roadmap, but you don't want to already explain all the stops and the reasons for each one of the stops. You know, you want to at least be able to keep your cards close to your chest, but to make sure that the commissioner clearly understands when something is being presented or when a witness is coming in, this is what they are for. But not giving away your entire case and your entire argument to put the opposing party in a position to be able to prepare and counter to that already. So my do's and don'ts is clear. Make it short, concise, to the point, paint the roadmap, but make sure that you don't divulge all of the information that you're going to be giving during your main case and the evidence part thereof. So I hope that answers Sammy's question.
100%. No, thank you for that, John Ray. I don't know if any of you maybe have a personal experience or a professional experience, kind of put that way, with opening statements where what you said actually really encompassed the essence of you know, the case that you were about to lead. No pressure if you guys can't think of anything on the spot.
Let me jump in. I think I've had once or twice had rather good success when presenting the points that I want to prove, where the opposing party is then seeing a little glimpse of, listen, this is where my argument is going to go. And in that moment, realizing that, okay, well, maybe they don't have enough evidence to rebut this line that we are going to take. Or sometimes even new information comes to light for the opposing party. So it's sometimes it's used as a good tactic to make sure that the other party also gets all the information, because you wouldn't believe how many times you sit across from an opposing party and not all the information has gotten through to them. You know, members and clients and, you know, people tend to tell you the version that they believe will be the most favorable to them. And during that opening statement, it might very well become clear that that is not the actual, the true nature of the event. So that has worked for me in the past.
Sorry, just a quick question that I thought of now, and maybe it'll be applicable to certain members, possibly unrepresented at arbitrations. Can you hold someone accountable to their opening statement? So say, for example, they said something in the opening statement which is maybe contradictory to the evidence they then lead later on. Is that something that you would address in closing arguments or pick out at cross-examination?
Yeah, look, I'd already point that out during cross-examination because, as I said, we're looking at which versions are the most probable. And obviously, if you have made an opening statement and then now later testify to the contrary, surely the validity of your argument or your statement should be tested. And the same if you are represented. I mean, if you've instructed an individual to act in a certain way, much like when you're bound by, if you've done a condonation application, you know, that the information that you provided there obviously already forms part of the record. So if opening statement and then inevitable evidence don't line up, I would point that out during cross-questioning already.
And that'll, in essence, tank the credibility of the person making that opening statement or the witness that is leading evidence to the contrary, which actually brings me into my next point, hearing of evidence. So there's certain different stages, and this all goes down to, mainly the credibility of the witness testifying, maybe the credibility of the witness under cross-examination or re-examination. So if I can maybe ask Kenneth, would you mind walking us through or breaking down the hearing of evidence? Where exactly in the process does it fit in? Not everyone knows the different stages of hearing of evidence, so I'll just put it up there on the screen. If you can maybe just walk us through briefly, if you wouldn't mind.
Thanks for that, Cole. Look, examination in chief is where you've now narrowed your issues and you gave your opening statements to the commission. And our examination in chief is where you're going to call your witness to tell a story. And the emphasis is on telling of a story because even seasoned attorneys, when testifying under oath, it's a stressful situation. So this is where your witness will give a story, tell what happened, and you would lead your witness, ma'am. And obviously, on the examination in chief, with your own witness, you won't ask leading questions. Ma'am, what did you do on the 22nd of October? You won't ask her, did you see this guy on the 22nd of October? I think that's very important. So your witness can tell the story. And this is where you give the basis of your case so that the commissioner can make a decision. And also, but what's very important in your examination in chief is to stick to what the commission needs to decide on. You've now narrowed the issues, and you need to testify on the issues that was not narrowed. We don't want our witness to testify on something that the commissioner doesn't need to decide on, because, and I love the phrase that John Ray used, you don't want to muddy the water. It must be clear to the commissioner what he or she must now look at. And to just get to the cross-examination, this is where you would try to defeat or shoot holes in your opponent's case. And test their evidence. Apologies. So when the witness on the stand has now testified, and you have the opportunity to cross-examine that witness, this is where you will need to dispute the evidence. And it's very important for under cross-examination to dispute that evidence and to put your version or your member or your witness's version to that witness. Ma'am, but I put it to you that this was said. Or what happens, and I think Edrich will also touch on that, what happens so often with us as officials on the ground is someone went through a disciplinary hearing, and there's, for example, minutes to that hearing, and they said something in that disciplinary hearing. Now, under their examination in chief, they change their story, and you'll test that evidence. Sir, but I put it to you, for example, you said A, B, and C 2 months ago in your hearing. Now you're saying something different. And this is how we're going to prove you a dishonest, for example, if it is a dishonesty charge. And I mean, on suits and stories and movies, you'll see counsel screaming and shouting. Now, just a personal trait, but you don't want to go and shout and scream at a witness, because the commissioner or the presiding officer will focus on the fact that you're now making a scene or you're shouting. The commissioner must still see, what are you disputing? I'm disputing this. If you go and scream and shout, the commissioner will be more focused on your demeanor rather than to show the commissioner, this guy is not telling the truth or he's changing a story. With re-examination, you'll just, if cross-examination through your witness has now taken place, you'll just ask your witness a few questions to the holes that now has been blown, just to patch up a bit. In past, I've refrained from re-examining witnesses. Sometimes when they struggle under cross-examination, it is a bit of a, I won't use the word risk or gamble, but it can be a risk to reintroduce that witness or to call him or her under re-examination, because they have now struggled, and you don't want your own witness to change her version in examination in chief, because the commissioner will pick it up, or presiding officer will definitely pick it up.
Thank you for that overview, Kenneth. I think it's a great way to introduce the discussion topics specific now. But before we build on further to that, I see we do have a question that just came through. The question over here is, can a fact that was not asked on examination in chief be asked on cross-examination? So I'm assuming a fact or question. So if something wasn't posed in examination in chief, can it then be, attacked on cross-examination?
Carl, let me take this one. Yeah, look, it's inevitably, and I'm going to get to it later when we're going to chat about cross-questioning again. You need to, being good at trial advocacy and courtcraft means that you are clear as to where you are going and what you want to prove. If a fact hasn't been testified on, it's not always necessary to cross-question on it, because that witness is bringing that testimony. But if there are certain facts that they have eluded or they've neglected to go, my advice would be to make those statements and put your version at least to the individual. It's a very difficult question to just answer, because every context will have its own answer there. But I mean, if we will be presenting evidence and putting someone, and for employers, sometimes the onus being on the employers may be better, because you're getting your version out there first and you're leading your witness. But if there's factual information that witness should be giving or has neglected to give, then my advice would always be to put that version, your version, to that employer, to the opposing party as well. So something just being left out and not being testified about, yes, you will inevitably in your closing argument say, listen, this evidence wasn't even presented before the commissioner, but nevertheless, I have placed our version to the opposing party during my cross questioning. So, Vadile, I hope that answers your question. It's please reach out in the comments afterwards if you have anything more specific, that you would like to discuss. All our details will also be added at the back end.
Thank you for that, Jean-Ray. I hope that answers your question there. If not, please, you can have a follow-up question that we can discuss. But building on to what Kenneth said now, and before we build on this, I just want to take us back to trial advocacy. When we think of trial advocacy, we talk about trial advocacy, we think of the courts. And, for us in the labor sphere, the courts, are the CCMA and the bargaining council. But my question is there a difference in the process of hearing evidence from the courts, the magistrates court, regional court, high court, to the CCMA and the bargaining council? Or do these three steps, form a basis of our litigation process? Just for the viewership to, clarify that.
Yeah.
If I can touch.
Yeah.
Sorry, sir. So yeah, with the CCMA, your onus is not like in a criminal case. In a criminal case, for example, you need to go and prove beyond the reasonable doubt, meaning that there should be no doubt that this person in a criminal case committed a certain criminal offense. With the CCMA and the councils in our line, you need to prove to the commissioner which version is more probable. Commissioner, my version is more probable on a balance of probabilities. On a balance of probabilities, this person, and again, I'm just using an example, this person was asleep at work. It happened 10 times. I'll show you video footage. And you just need to the commissioner, and in our instance, just need to decide on which version is more probable. And I think it's something that people tend to forget, but it happens that you try to prove on a beyond the reasonable doubt. But if you can just stick to the which version is more probable, that is the difference on the onus that one should prove. So in a criminal trial, obviously it's a bit more difficult for the prosecutor in that instance to prove beyond reasonable doubt that this person committed offense. We just need to go and prove, well, it's not as easy as it seems, but need to go and prove that our version is the more probable version in which the dismissal was.
Sorry, Kenneth, I think you've muted yourself there.
Oh, sorry, I was a bit quick on the mute button. We just need to go and prove that our version is probable to prove it that the dismissal was fair, and not necessarily on a beyond the reasonable doubt.
I think going on what you say now, it actually is, if you break it down to simple terms, the commissioner must decide in a logical and reasonable manner which version before them is more probable, based on the evidence, based on the witnesses. And I think that's where we bring the complexity and the professionalism to it, where we lead the evidence and the witnesses in a specific manner that sort of unpacks and paints this more clear picture. All right, something I think that is a burning question that I wanted to know when I was studying law back in the day, but a focal point of many legal series is, the dramatic cross-examination of witnesses. Now, for any young professionals out there, maybe people who are students right now studying law, is that a good depiction of, how it actually goes in practice?
Carl, let me take this one. Look, my opinion would be no, that it doesn't really. One must be very, very wary of taking that type of mentality into cross-questioning sometimes. I spoke about trial advocacy being the dance. If you take cross-questioning, it is probably the tango. It's the one that comes with a lot of passion, and it gets depicted as this extremely aggressive thing sometimes. My advice would be, and I'm going to go back to the basics here, and I'm always talking about the muddy water and stuff like that. Know what you want to do with cross-examination. Ensure that you stay cool, calm, and collected. Because, and I think I'm jumping ahead to one of the questions as well, as what would I advise someone that is going to be cross-questioned? So my first advice would be to stay calm. The truth should prevail, and all the semantics around it shouldn't really matter. So the point is to stay calm. But that advice I would give to the witness and the individual who's going to do the cross-questioning. Make sure that you know where you want to go. Sometimes less is more. It's not always necessary. And I always tell the story. I was once up against one of my learned colleagues. He took about 2 days to cross-question 3 witnesses. And it was this way and that way, and trying to make clever statements, and obviously trying to solicit an emotional reaction from some of these witnesses. Versus when the applicant got to the stand, I was lucky enough to ask 5, 6 questions, and we were done in 12, 13 minutes. And I ended up successful in that method. But just knowing that it's not always about the theatrics. Yes, sometimes, especially when you're pressing someone who's clearly being dishonest or trying to hide something, and that emotional will come naturally. Unfortunately, that is the way of the world. Most people are not inherently dishonest. They are honest beings, and when they are being dishonest, an emotional reaction comes out there. But make sure that you are the one that controls that emotion. If you are the one doing the cross-questioning, make sure you know where you want to go, and you keep the emotion as far out of it as possible. So that would be my advice to young litigants coming up.
Great, John. I think you hit the nail on the head. Something that we do in our training for our dispute resolution officials is we teach cross-examination as a forensic tool rather than this dramatic, I need to attack this person. And it's achieved through a calm, cool, and collected manner. You need to achieve the objective you set out for that witness and lower the credibility of the person that you're questioning. The purpose, as you say, has to be specific to that witness. And it can be to underline something, undermine, or maybe even to explain a point. Not every witness that you cross-examine is going to just blurt out and admit that they're lying under oath or something like that. So thank you for that. I really appreciate it. Before we move on from the hearing of evidence, I have a question for Edrich. And again, because he deals with this on a daily basis with Kenneth, what is your approach to cross-examination? Are you more aggressive? Are you cool, calm, and collected? I mean, your demeanor is very sort of mysterious and quiet, well composed. So I'm quite interested to see how you go about cross-examination.
Yeah, thanks, Carl. I think, like we said in the beginning, it's important for you to know how you are as a person and the type of questions that you are going to ask. It's always funny to see in movies how the Americans go and shout and throw their pens in the air and do all of this. And I think that's the picture out there how cross-examining should be. But I've noted that the more the applicants sometimes feel that he's in this environment that he's speaking and he's believing that you think he's telling the truth, the more he speaks. and it opens up sometimes a lot of holes in his evidence. You know, if you tell if you are there to say, well, tell me more, I hear what you're saying, what happened then, and he's got this premeditated story that you thought out so well. You know, it opens up a lot of holes in his evidence at the end of the day, because if you are going for, and that's just my opinion, and if you're going there from the start and tell him, so I put it to you, you didn't do this, and I put it to you, you said this, and I put it to you, you this, then he might answer you in 1 or 2 words. But if you are there to make him feel that, okay, you know, he might be telling the truth, then later you can always go back to the minutes of the hearing and tell him, sir, I put it to you, you said this and this, but according to the minutes of the hearing, you didn't say this. So I'll take an approach to make him believe, or make him believe himself. And you know the minutes of the hearing, and you have heard his evidence, and then it's important to still put your version to the commissioner and to him to say that this is not a truth and this is why it's not a truth. Then you can put it to him. But for me, from the start, to be aggressive, I think it's not the way I go about it.
Yeah. I think it also, that ties back into what Jean-Ray described as trial advocacy. It is individualistic. People take different approaches, and it's a skill that is based on your inherent traits as well. Thank you so much for that, Ed. Just for time constraints, guys, I know we would love to talk about this all day. I'm pretty sure we could do a series for a whole week on trial advocacy alone. But based on the time, we need to be moving on to closing arguments. My first question here is, what are they and where do they fit in? Are they even necessary? Ed, you were now speaking about cross-examination. Maybe you can lead us into closing arguments as well.
Yes, thanks, Carl. Yeah, closing arguments is there when both parties have, completed a presentation of their cases, and opportunity is afforded to deliver then closing arguments. Now, for a closing argument to be compelling, it should summarize the facts on which you rely. So a compelling closing argument will then place the proven facts into perspective in the commissioner's mind. So, I mean, you need to do in your closing argument, it's the end of your case, and then you need to prove to the commissioner that why is your case more probable than the applicant's case. And you can do that with stating case law in your closing argument. Certain awards that was made in the past, and why is your case more probable than the applicant's case. So I think a closing argument is very important to summarize what was said, why the applicant's case cannot, or why the commissioner cannot believe the applicant's case. And you can tell the commissioner that this witness is not credible because of X, Y, and Z, and your witness is credible because he testified to that, and that was the case from the start. So it's just to summarize and just paint that picture clearly to the commissioner with case law or legislation, and to summarize it all.
Thank you, Ed. Yeah, I think that is a great introduction, and is how I would probably explain the closing arguments to one of our members as well. Jean, just a question for you, and I know there's not a one-size-fits-all approach when it comes to closing arguments. I think with many things in law, and members probably get sick of us saying this, it's specific to the circumstances and the facts before you, but could you maybe walk us through a structure of a persuasive closing argument? How would you structure one?
Yeah, thanks, Carl. I don't want to reiterate what Edrich has now said, by just saying it differently. But much like, the opening statement was listen, this is the roadmap, how we're going to get there. Your closing argument is basically having a look at the photos after the journey, and saying, listen, this is what we did during the process. So obviously, we're going to start right back at the narrowing of the facts. You're going to reaffirm that in your closing argument, and you are then going to address, I would believe, chronologically the background, and then go and address each one of the points in dispute. I enjoy doing that in a very professional manner with headings to say, listen, this is how we got here. These were the points in dispute. I wouldn't regurgitate again the witness testimony and everything like that, but highlight the salient points that I want the commissioner to, or the presiding officer to consider. And then obviously give it that little bit of meat with the case law or the legislation that backs it up for me. So that's basically it. A nice summary of, these are the points that I needed to prove. This is the witness testimony I want you to consider. This is the legislation that that I will be relying on, or that I have relied on, and that I want you to consider. And then finally, obviously, we didn't really touch on costs, but also here to make sure that, listen, if you are requesting costs in a matter, to give the breakdown of the costs and the reasons why the commissioner should be giving you the cost. So that is a good structure that I like to follow when submitting my closing arguments.
Sorry, I know we're a bit pressed for time. Thank you for that, Genre. Just one more question from my side before we have to wrap this up. Would you say closing arguments are always a necessity? Can it be done in writing? And what would you say to a commissioner who says it's not necessary to do closing arguments?
Okay, so Kenneth unmute there, but let me take it. Look, yeah, it's where I would sometimes dispense. I know in the informality of CCMA proceedings, we spoke about commissioners wanting to dispense with opening statements. I would insist to do a closing argument. The closing argument, especially, matters vary. Sometimes a matter is an hour long, sometimes it's 5-6 days long over a period of 2 years. And it becomes very necessary to not just for the commissioner's sake, but for your own sake as well, to just go and summarize and end off your case as to what was taken into account or what should be taken into account. If the matter is short in nature and the points in dispute are few, verbal would be fine. But I wouldn't advise a matter that's gone over 2 days or even 3 days. I would advise that you request to have it done in writing, so that you can also go and work through your notes and summarize it nicely for the commissioner. So that would be my 10 cents there.
Thank you, Genre. I appreciate that. I think we're going to have to wrap up. Is there anything further that you guys want to add, Erich, Kenneth?
I just wanted to touch on what Genre said, Cole. Closing arguments, specifically on the point that if it's a lengthy arbitration, I'm busy with a matter that's been spanning for 5 or 6 days of arbitration over a course of a few months. Now, in such an instance, I would request the commissioner, can I do this in writing? Because the commissioner forgot what my first witness said 6 or 7 months ago. And then when the commissioner sits with the written closing arguments in front of him, he would be in a position to remember, or rather to recall. In such an instance, I think written closing arguments is, but again, like Genre and Erich and all of us say today, it's a personal trait, and that's also just a personal trait. Thanks, Cole.
Thank you. I have a question over here. Will it be taken as an irregularity if the presiding officer insists that closing arguments are not necessary and the parties relent?
Yeah, look, again, we're talking about us that appear in the CCMA sphere, and there's a lot of powers given to commissioners to make the processes less legalistic or less formalistic, and therefore they have in accordance with their discretion, they may regulate the process, how they see fit. So it wouldn't automatically result in an irregularity. I must say, in my experience, I haven't seen a lot of commissioners that are that against the closing argument. So I don't think it happens a lot. But again, one needs to go and place on record. If you feel that you're going to be prejudiced, or your member's going to be prejudiced due to a lack of a closing argument, you need to place that on record. Unfortunately, the commissioner runs the process, and I wouldn't advise that you now get into an entire fight and at that point apply for recusal, unless there have been irregularities during the entire process. So not always 100% necessary to always be in a fighting and adversarial persona when you go to the CCMA, but if it is prejudicial, it will inevitably be seen as an irregularity on review.
Yeah, I think the main element there comes down to the prejudice of, you know, your member's version or your client's version, and also whether there's case law to support your case. Because if you are leading legal precedent, that was where you would be, you know, putting it onto record. So if they dispense with that step, you wouldn't have that opportunity to support your version with the case law. So I hope that answers your question over there. Guys, thank you so much for your input and the discussion today. That is unfortunately all we do have time for. This hour's gone a bit too fast. I would love to, you know, discuss this further, but I just want to say from my side, thank you so much for your guys' expertise, for your guys' opinions, and, you know, professional input here. I think it has been quite valuable to the people in our viewership watching, our members. From my side, Jean-Ray, Edrich, Kenneth, thank you very, very much. And yeah, without further ado, I just want to touch on the further training that we have ongoing. We are doing this monthly series, you know, every month, and we are looking at scheduling our November session towards the end of November. So please keep an eye out on all our social media platforms for the advertisement of that. I think it should be quite an interesting take. We do have specific member and prospective member training as well. So if you are interested in that as a member of CEO or prospective member, please feel free to reach out. I will put our contact details on the next slide. And then, yeah, keep an eye out for our training schedule. Just one last thing before we go. There is a, I forget the name now, a barcode that you can scan, a QR code, that's the one. I was thinking of a barcode that you can scan there for all our viewers watching. It will take you to a separate web browser page where if you just put in your email address, you will get a free available copy of our CCMA rule booklet and guide that was developed by CEO. So please feel free to scan that. Thank you so much for attending. Jean-Ray, Edrich, Kenneth, again, thank you very, very much. Please give us a like and a share on all our social platforms. And from my side, I hope you guys found this enjoyable and valuable. Thanks, everyone.
Thank you, Paul.
Thank you very much, Carl.
Have
a great day, everyone. Goodbye.